disappointed me. Yes, I want to thank you. We have a substantial number to start with. I understand you had a fantastic time last week, Thursday. For those of you that were here, I apologize for my presence. It's for the good of everybody. So, but I was following in the spirit, and I have since listened to the video recording. Now, one or two people have asked for the video recording. Please contact Femi. Maybe I will withdraw my permission. It's my pleasure to we deliberately put this program her WhatsApp. I'm now in Ife. Me, I was saying, how far? She said, my how far, I'm not sure I was able to send it. When I saw, I'm now in Ife. So we want to appreciate you, madam. She's Tiwantiwa, BSc, PhD, OAU. I will leave the rest to... She has a lot of... Olimark.
Good morning once again. It's good to be here. I have the honor to introduce our resource person for today's program. She's a barrister and solicitor of the Supreme Court of Nigeria. She's a professor and head of Department of Commercial and Industrial Law, Faculty of Law, University of Lagos. She's a pioneer substantive professor of intellectual property, Masters in Intellectual Property program jointly organized by World Intellectual Property Organization Africa, Regional Intellectual Property Organization and African University in Zimbabwe. She's a fellow of the International Labour Organization Training Center, Italy, a fellow of the World Intellectual Property Organization, Switzerland, Geneva. She's a fellow of the Max Planck Institute of Intellectual Property, Competition and Tax Law, Munich in Germany. She's a visiting scholar, Franklin Pierce Law Center, University of New Hampshire in USA, World Intellectual Property Fellow at the Franklin Pierce Law Center in USA. She's a capacity building consultant in intellectual property law, labor, employment law, and other subjects in the commercial and industrial law field. And so many positions she has occupied. She's an author, a co-author, a reviewer. She's a sub-dean, presently Faculty of Law, University of Lagos. She's the one coordinating the Masters of Law program in the University of Lagos. She's an editorial board member of Nigerian Institute of Advanced Legal Studies Journal of Intellectual Property. She's a legal advisor, West and Central Africa Division of the Seventh-day Adventist Church. She has PhD from AWOLOWO University in 2011, Masters from Hampshire in 2000, and another Master LLM in 1991 from Unilag, LLB from OBAFEMIF AWOLOWO University. She has received so many awards. Let's make welcome our resource person for today, in person of Professor Adejoke Omolola Oyewumi, and she'll be handling strategic research and intellectual property. We can do better. Please, let's celebrate her. Thank you, ma'am. Thank you very much, Prof. Yes. Well, I'll just put my left here so that I can yeah, it's okay. Ekuleo. Good morning, and thank you very much for extending this invitation to me. It's always a great joy to come back to my alma mater. I had to come early because normally on such trips, I make a stopover at my home faculty. You can imagine that the first 3 years of undergraduate studies here, and then the many years on the PhD here as well, and also some collaboration at different times. So it's always a great pleasure to be back. And I want to thank Professor Kendi and the entire team for the invitation to come and share some thoughts on strategic research and intellectual property. As I was coming in this morning, I asked Prof about the audience. What faculties are they from, so that, you know, the research will be tailored to fit the purpose. And she told me that all the faculties are represented or will be represented. And I think that that is really, you know, we have come a long way from the past when intellectual property was thought to be the exclusive preserve of lawyers. When I joined the University of Lagos sometime in 1992 as a lecturer grade 2, intellectual property was introduced around that time. My head of department wanted us to start the course, and that was why they hired new lecturers. The course was domiciled in Faculty of Law then. But something happened in the year 2000 when I went for a training, a one-year master's program in intellectual property in the US. When I got there, I found that we were only about maybe 5 lawyers. So in our intellectual property class, we had those from health sciences, we had engineers, we had pharmacists, and I was looking around and wondering that, isn't this meant to be something for lawyers alone, you know? And that was when my thoughts, my outlook was considerably broadened regarding the scope of intellectual property and, you know, the different applications in different contexts. Today we know that intellectual property is generated in the course of our activities as teachers, as researchers in the university. We know that in some other countries, intellectual property is a major source of income to the university and to individual researchers. That it's not just about lawyers knowing about intellectual property to be able to fight infringement cases and help intellectual property owners to protect their rights, but it's about a whole value chain of intellectual property, which starts from those that create or generate the intellectual property to those who administer it, who manage it, and then perhaps ends with those who help to enforce the rights in the event that it is violated or infringed.
So who are those who generate the intellectual property? Who are those who are involved in the management of the intellectual property? And who are those who play vital roles with regard to enforcement of intellectual property? Slide 1. I'll start by perhaps stating the obvious. That is that universities are the factories of the knowledge economy. And when we are strategic about research and the attendant intellectual property output, it affords another mechanisms for us as universities to contribute to the development process. And this is by disseminating the knowledge that we generate through research activities and to have that knowledge used in the economic sector. University of Ife was established in the early 60s, ditto most of the first generation universities. You can imagine the number and degree of knowledge that have been generated over time in the course of the last 6 decades. Sometimes we generate the knowledge, we use it maybe in the course of our research, we publish our papers, we earn our promotion, we obtain our, degrees and all that, and the knowledge remains stored, is left or ignored inside the file somewhere. Those who find their way back into the academia pass on the knowledge to others. So we are very active when it comes to lecturing, when it comes to publication. Indeed, we are often told when we join the university that we should publish or what? Perish. But these days, the mantra is no longer publish or perish. It is now publish, patent, and what? Prosper. In other words, when we generate our intellectual property, it goes beyond being in a hurry to put it out there. There are some things that we must do first in order to ensure that we are able to generate wealth, we are able to add value to society through the intellectual property. Next slide. Now, the traditional roles of universities to teach and research have expanded, and we now engage in technology transfer activities. There's now, increased awareness of the need for collaboration with industries and so on. And in some parts of the world, available statistics indicate that universities make much more income, than through their research and intellectual property than through other sources. To be able to key into this, universities like ours here need to be strategic in our research. And this strategic research means research that has strategic, economic, or long-term commercial value. So we are deliberate. We target, particular objectives. And we include this. The university management would normally be required or expected to do this in the strategic plan of the institution. Countries have strategic development plans. Industries have it. Universities need to as well. Then I have some examples there of universities that have been strategic in research and the outcome. Some universities, especially in the developed countries, that have, through patents obtained in respect of their research activities, contributed to diverse sectors. It could be the health sector. These days, we're talking about COVID, isn't it? And the need for adequate responses to the new pandemic. We also have problems with our electoral processes. Some universities have generated research that resulted in a particular technology used in tracking of election results. In other words, we are talking of research that targets society, targets particular sectors identifies problems in these various sectors and targets the devising of a solution to those problems. Now, perhaps a bit late in the date, but it said that it's better late than never. So we find that increasingly our universities are also waking up to the challenge. I remember when I came back after my program in, I think, 2001 or so, and I was trying to make a case for the introduction of intellectual property in some of the faculties, especially engineering and pharmacy. And, you know, it was thought that, what's she talking about? They want to introduce more law courses or all that. But today, I'm happy to say that at my own university, and I can see it's happening now, because I also met some of the members of the Research and Innovation Office when we went to start the program for capacity development in intellectual property at Zimbabwe. That was at the instance of the World Intellectual Property Organization. I think I met at least 2 or 3 of OBAFEMIF AWOLOWO University team members on that trip. So now there's increased awareness. We now know that it's important to have a research and innovation office. We now know that it's important to have an intellectual property policy for the university. Next slide. So in this session, we're going to look briefly at the dimensions of research. Okay, basic research, applied research, and with your permission, I hope this is going to be interactive, because some of the things that we want to be looking at are things that you may even know more about, especially those from the sciences and engineering. So we'll look at the dimensions of research, and then we'll look at what I will describe as models, you know, of strategic research plans, and then we'll look at intellectual property. What really does it entail? Is it only for the sciences? What about those in other faculties? Where do they come in? How do they come in? What are areas of comparative advantage that we need to really leverage on, you know, for purposes of strategic research? Which IP rights are relevant in a university context? How best can such rights be harnessed and managed for the maximization of the benefits to the university as well as stakeholders? And what institutional strategies should be deployed to ensure a buy-in by all stakeholders? Because, I mean, it's one thing for a certain sector to see the importance and value, but it's another thing to be able to carry everybody along. Please. So when we talk about research, the ordinary meaning of research can be understood when we look at it as not just a search, okay? When you are searching, maybe you are searching for something new. When you are researching, you are reopening the same, you know, study, reopening the same a vista, you know, with regard to a particular segment. So we're looking at the dimensions of research. And I know that among scientists, we have different categories. We have the basic research, we have the applied research. And from the applied research, we can also, you know, bring out research which is deliberate and which is strategic. So I don't know whether anybody wants to help me being and not being too vast in about, I don't, between research and applied research. Who wants to help us? What's basic research? When we say research is basic. what does it mean? And how is it different from applied research? Okay, thank you.
Yes, my name is Ada Okonji. I'm from the Faculty of Basic Medical Sciences. So my understanding of it is basic research generally is not aimed at bringing out a concrete, a physical outcome. The outcome from a basic research basically cannot transcend into commercial value. For instance, let's assume let me just use a case scenario to describe it. I want to see if using weight beams can increase the muscle mass of an individual. For basic research, I could just go and search that database, for instance, and a systematic review and see what other people have done. Those kind of findings, basically, you can refer to them as basic research. But now, if I now decide to experiment, make a weight beam myself, probably put sand in a bag and decide to use it and say, would something containing sand or basically what we buy in the shops, the normal weights we use, the normal dumbbells we use. If, for instance, I just put sand in a bag for people in the grassroots areas, will it still do the same work? I weigh 1 kilogram of sand and I compare it with what is already being imported from China. Would it still do the same work? And I find out that the locally made sandbags can also have the same effect as the dumbbells we buy in the shops. Then we can now begin to package. In fact, right now in the physiotherapy department, there we sell sandbags for patients that cannot afford dumbbells. Thank you.
Please clap for her. Wonderful example. Wonderful because she has not just attempted to define the concepts, she has also given us a practical example. And this is really where the distinction lies. You know, basic research helps to increase knowledge generally. It could be theoretical knowledge, it could be abstract knowledge, and it's very important in the university context because basic research often provide the building blocks, isn't it, or the foundation for applied research. But basic research is not always necessarily directed towards or targeted at specific outputs or outcomes. It's just an investigation. We're trying to find out, you know, what is the components, as it were, of the dump bags or whatever it is that my sister from Basic Health Sciences was talking about. But when we now want to apply the knowledge, you know, we want the research to be applied. Now, let's use maybe a more familiar example. When the COVID-19 pandemic started early last year, and there was this general panic, and we found that certain equipment would be required, isn't it, for those with advanced cases of the COVID infection. What was the machine or equipment required? Ventilators, yes, to help in easing the breathing, isn't it? And then we found that a number of institutions, organizations started doing research. That research was not basic research. It was what? Applied research. Because they were trying to come up with new models of ventilators that would be more easily accessible to us here. So the research was targeted at a particular problem or a particular solution. And I mean, that's one example, needs-driven research. We have a number of others in diverse sectors. It could be in the health sector, it could be with regard to transportation, it could be with regard to the environment, it could be with regard to even household gadgets, household equipment. It could be communication, information, and so on. We can cast our minds back to remember the time when we did not have our mobile phones, isn't it? The time when we were all at the mercy of a NITEL, and we could only have the land phone. We also remember the time when we had only our desktops. Now we have our laptops. We have all these communication and information gadgets that make life a whole lot easier. And we also remember back in the day when to cook, I can see there are a lot of female colleagues here, when cooking was a major challenge because, I mean, I remember those days when our mothers, grandmothers would spend the best part of the day in the kitchen, isn't it? Because before breakfast is done, then it's time to start on lunch and all that. No refrigerators, no microwave, even the cookers, you know, were not the easily applied ones, and so on. So, applied research is one that targets particular societal problems or issues. Now, there are a number of health situations, health conditions that we have some solutions, curative, even preventive strategies being deployed to address the problem. Back in the day, catching certain kinds of infection, respiratory or digestive tract infection would mean not just the likely end of the person, but also a substantial number of people around there, isn't it? But now we have the, you know, antibiotics, and from the 6 hourly ones that you wake up in the night to administer to the more sophisticated ones that are more user-friendly. Well, what we are saying in essence is that society has come a long way because those involved in research have taken it beyond just abstract or theoretical research to targeted research that aims to address societal problems. Please go on. We've talked about this already. Okay, so when we talk of strategic research, I want us to look at other terminologies that would mean the same thing. Like what? Deliberate, isn't it? Targeted, tactical, well thought out, planned, calculated. So it may be coincidental, it may be random sometimes, but we are talking of a situation where we look at our society and try to find a solution to the issues or the problems that we have. Some years ago, we heard, I don't know how far it's true, but the available information out there was that the pounding machine was initially, you know, invented by a researcher from this great university. Yes. What usually happens in such situations is that our researchers have an opportunity, you know, sometimes to maybe go for research fellowships and all that. And recently, a colleague still had the same problem that, look, she was to go for a research fellowship, and there were some things she was asked to sign. But because we've had quite a bit of awareness raising in the university, people are now learning to ask questions. And they are now learning to show their contracts to the lawyers or to the those in the technology transfer office before they just sign. Previously, I mean, they'll say, oh, we're going to give you maybe 2,000 or 3,000 per month for 6 months, and people will sign everything away and, you know, just go. The colleague said, can you take a look at this, you know, and all that. So there are a number of, because the developed countries from where we import the yam pounder and other things don't eat pounded yam, isn't it? But we find that somehow they are the ones who get to claim the patent for it. They are the ones who, you know, begin to manufacture it and so on. We are blessed that at least our eminent prof remains acknowledged, you know, which means that maybe he was before his own time to ensure that his name continue to be linked with the research and development project which he came up with. That's the yam pounder. But we find that if we don't pay attention to many of these things, sometimes what can generate so much money, we're talking of thousands, if not even millions of dollars, as the case may be, for the researchers involved, for their home faculties, for the university, will be lost because we sign everything away readily. Sometimes also, because we don't understand the requirements for protection of intellectual property, we come up with this research outcome, and we are quick to write our papers, we are quick to publish the papers, in which case the information gets into the public domain before we have taken steps to safeguard or protect our intellectual property. And intellectual property largely protects information or inventions that are new and that are inventive and useful in industry. But that newness is important. And newness is lost once the information has been put out there in the public domain. Does that mean we should no longer publish? No, that's not what it means. What it requires is that before we take steps to publish, to disseminate the information, we should first of all pay a visit to the Research and Innovation Office or the Technology Transfer Office. Different universities and research centers use different nomenclature to suit their own purposes. And we should seek preliminary advice on whether that invention is protectable and what steps can be taken. Once the application has been made to the Industrial Property Registry for protection, then it can be disseminated, because the date of the application would show that before this thing was disseminated, it was not known. But once it's already out there, you really can't take it back and say, oh, now I want to protect it. They'll say, but isn't this what we read in the newspapers, sometime last year? Isn't this what we saw when we went for the exhibition at so place, and all that. So that's very important, being strategic and particular about our creative and inventive outputs. Next slide. Just go on. Go on. We've talked about. Go on. Okay. Please go back to the one before this. I want to talk about the importance of collaborative research also in the context of being strategic in our research. So far, the emphasis has been on the sciences, the health sciences, physical sciences, and so on, and engineering. But the fact is that these days, collaborative research is very important. I like to use an example, which we may still come back to down the road. And that is something that I think constitutes a strong, that gives us, that can be compared or described as a gold mine, which is yet to be explored in our own context. And that is nature-based products, inventions made from natural resources. So we have, for example, our biological resources. We have our plants, we have our seeds, and so on, isn't it? We have a rich ecosystem. Then we have traditional knowledge holders, those who know what can be used for what, or what is useful for what. They know that, oh, if you use certain leaves, or if you boil certain leaves, or you take certain seeds, it's useful in curing certain or particular ailments. I remember the example, and I think this is common to most African countries. In South Africa, for example, there was a particular species of cactus plant, which was discovered to stave off hunger. How was it discovered? Through the traditional knowledge holders. The hunters discovered that they could go for miles, sometimes even for days, without feeling hungry once they had just small bits of the cactus, the species of the cactus, the plant, which they would just chew from time to time. Subsequently, those involved in research and development in the area of health management, weight management, and so on, developed this into a medicine, a drug, useful for managing the weight. And the way it worked was that once taken, it would just stave off hunger. Was that a new invention? Totally. Or was it an invention that developed based on the knowledge of traditional, traditional knowledge holders, medicinal knowledge holders? And we have so many different natural resources like that. The ones that act like vaccines, the ones that help to stop postpartum infections or bleeding, the ones that are useful in diverse sectors. Some have even been used to help to manage addiction, drug addiction, all based on traditional knowledge. These days, for those who use many of these herbal remedies, we are told that this one is not even a medicine, it's a food supplement, isn't it? And the thing is put together, and they are told, if you can take this, it's an antioxidant, it can do this, it can achieve that, and so on and so forth. Are they made here? Are they made here? No, they are usually imported. But available research indicates that many of these products actually build on the information freely obtained from traditional knowledge holders in, African countries. And that's why, or how the term biopiracy came to be coined. Because you find that researchers come from elsewhere, interact with our knowledge holders. We find that many of our people are very open and welcoming to strangers, isn't it? We are ready to share our information and so on. And then they take some of these things away, develop it further, and when it comes back, even we cannot afford it anymore. And yet the original knowledge came from here. But what do we have in the market? Is it that we don't know about it? Is it that there is no effort to commercialize it even here too? Is that the case? But when we look at the bottle of, maybe our people gather bottles, used bottles, and wash it. We don't know how it's even washed or cleaned. And they put the liquid inside. They say, this is what it is. And you're looking at the dark, menacing looking liquid inside a dirty looking bottle. Are you going to buy it? No, poor packaging, no laboratory analysis to even indicate the correct dosage or anything like that. So, where collaboration comes in is having us, maybe those that are in the relevant fields, to explore collaboration, the possibility of collaboration with some of these knowledge holders. If the thing is discovered here and is prepared here, tested here, properly packaged here, then we can, claim the credit for it. We can earn the money from it and create the market for the product. And the collaboration would not just be between the traditional knowledge holders and our own researchers, because then it will be maybe be restricted to those in pharmacy or in the sciences, But we know also that packaging is very important. Sometimes it's even the packaging of a product that attracts us to it, isn't it? So we find that others who may be in the arts, in design, fine art and so on, they can help us. This is the product, can you come up with a concept, isn't it, for the packaging? They can help with that. And then we're writing out the information about the product, how it will be used, the dosage and everything. You read some information on certain products, home-based products, and by the time you begin to see the grammar hitting each other, you are afraid for your life that, it's like if something is not well packaged and not properly described, when there is no deliberate marketing strategy in place, which is where the business administration, management sciences, and others come in, then we find that, we are just shooting ourselves in the foot. We cannot continue to operate in our own individual enclaves. We have to cross-fertilize ideas, be open to one another in the different faculties or in the different sectors. Still go back to Stanford. I wanted to take an example of a quote from there. Over there, they said their approach to research collaboration starts by carefully studying the problem and its context. When you study a problem and its context, which group of experts or scientists do that? The social scientists, isn't it? The sociologists, the historians, and so on. So they study the problem and its context. Then the lab incorporates expertise from the relevant problem domains. So if it's a problem with education, COVID made us to be aware of the need for online education. Maybe we were aware of it before, but it's really, made it inevitable for us to begin to engage in that. So such as education or healthcare, as well as general social science insights. The tech firm toolkit, that's from the technology sector, is then applied to create a data-driven approach to innovation. So often we start by analyzing historical data, and that's where the arts, history, and so on would come in. Then we proceed to develop approaches to measurement and experimentation that promote rapid testing and data-driven. In other words, their approach is collaborative, and everybody has a role to play. Everybody has a role to play. There are some products that will come to the market. The scientists know that, oh, this is very good, it's very effective. But for some reason, people are not open to it. They are not open to the idea. They are not open to the innovation. And I can give an example even in my own field. Sometimes we engage in research. We talk about law reform in certain areas. We say, oh, certain things violate the human rights of particular, groups of people deemed or considered to be vulnerable people. So sometimes we look at women, sometimes we look at young children, the youths, and so on. But the reform proposed, which we say is now human rights compliant, is not welcome even by the community that is being sought to be protected. Why is that? Because there is no proper understanding, isn't it, of the social dynamics of that particular sector or that particular group. So what needs to be done? It's not just a matter of looking at international human rights norms and saying this is what we need to do now. It's understanding the psychology, you know, the mindset of the people concerned and why they will be open to certain approaches or reliefs while they will shun and avoid others. Because to them, embracing certain practices or certain innovations may make them outcasts in their society, in their immediate society or environment. So it's important to understand, to have a broad-based understanding of how those societies function, what matters to them, what is important to them. And then we look at the problem and we are able to come up with solutions. Please proceed. Okay. Before, please move forward. Just go on. I want to go to, okay. Now, looking at intellectual property against this whole background now. What exactly is intellectual property and what does it cover? What are the different types of intellectual property and in what sectors are this intellectual property rights relevant? Next slide. Okay, so intellectual property refers to rights that result from intellectual, creative, or inventive activities. Intellectual property sometimes is described as some of the finest manifestations of the human mind. It is called property because it belongs to the inventor or the generator of that, that idea or that concept. And it is intellectual because unlike other forms of property, I mean, maybe the car I brought, I got it from, the car belongs to the University of Lagos. Or I can drive my own car. Or I can inherit a house from my parents. Or, my friend can give me her books or her bag. But my own intellectual property is something that comes out of me, of my mind. It's a product of the mind. And so it is often said that there is no property that is more peculiarly a man's own than the one that results from the exercise of his mind. So intellectual property is like, being able to say, oh, this is an extension of the personality of the creator. And you don't want somebody else to be you. You don't want somebody else to claim that, oh, I'm Dr. ABC or I'm Professor XYZ, because probably you have spent, some time and effort building up a name and a reputation for yourself. That's the same as intellectual property. But because of the nature, it's an intangible property. I can lock up my car and put the key in my bag. I can lock up my house. But intellectual property is intangible. It's not something that can be locked up like that. So once it is created and it is disseminated, it's very difficult, if not impossible, to prevent others from having access to it or using it. And so that's where the law comes in to say that to confer certain rights on the on eligible persons, eligible owners of the intellectual property, to say this can only be used with permission, or this can only be used in a limited way, and also to provide mechanisms to encourage and support innovation, creativity, inventive activity, by ensuring that those who invest their time and their effort and labor in this effort are supported and encouraged by the law. And then we have different categories, two broad categories actually. There is what is called copyright and related rights, and then there is industrial property. So copyright, for its part, is the Well, when you use the literal meaning, copyright, that means the exclusive right to copy. That means you have a right to prevent others from copying the work. When you write a book, for example, or you write a poem or a piece of music, you know, all those artistic works, creative works, and so on, they are all protected by copyright. 6 categories of works are protected, including literary works, musical works, artistic works, cinematograph films. That's films. We know, of course, that the film sector is one of the most vibrant in Nigeria now. And then sound, you know, recordings and broadcasts. All these are protected by copyright. And unlike industrial property, copyright does not have to be registered. But there's a notification scheme which is operated by the Nigerian Copyright Commission here. And the advantage of that is that when you file your work there, it serves as evidence in the event that down the line you see somebody using it, or maybe in the course of, you know, when you generate intellectual property, you may not be the one to commercialize it yourself. So sometimes you are trying to discuss, you know, the possibility of commercialization with others, and they go away with the information. That often happens. I remember a colleague many years ago in the insurance sector who came up with the idea. I think it was, they were about in their group, they were about the first back then to talk about this form of insurance, which many schools have now adopted, where the students, you know, parents will pay a token amount, and in the event that something happens to the parents, then the school will take over the fees and all that. And they shared the information that, oh, they had approached quite a number of organizations, and that happens so many times, not just in the insurance industry. I've seen it with engineers. Some would go to oil companies and say, look, we have a solution that can help to deal with the problem of rusting of pipelines. We have a solution that can deal with environmental pollution. And initially they will be given access, you know, come and talk about what you've done, share the information, they submit the papers and whatever. And then after some time, they're no longer welcome there. And these are real life examples. Some will degenerate to court cases. You can imagine someone trying to take, I won't mention the name of the particular oil company, but a multinational oil company to court. Those that have intellectual property offices, intellectual property lawyers, up to several hundreds on their team. So the matter would go from the High Court to the Court of Appeal, from the Court of Appeal to the Supreme Court. At the end of the day, you are looking at some 15, 20 years and a lot of money, very expensive litigation. At the end of the day, it's not even certain what may come out of it, especially when the proper steps are not taken at the beginning. Because the question then is, what is the evidence? They will say, oh, our research team was already involved in this before. This is what is called an unsolicited proposal, you know, and all that. And there's even no evidence. Okay, did you send it by mail? Do you have any acknowledgement? Is there any evidence? No. Then you start trying to bring people. Oh, I know the gate man who used to open the... which of the staff will testify again? Do you understand? So the whole thing gets very messy, and this is all because people don't take steps to safeguard or protect their intellectual property. That's why having an institutional approach where you go through the institution is, you know, always very important, always very helpful. So, copyright and then industrial property. Industrial property has different types or different subsets. We have what is called patents. patents refer to the arm of the law that protects inventive activities. When you invent something new, that something can be a new product, it can be a new process, a new method of doing something, and it must be something that is useful in any sector, in industry, in agriculture, in health, anywhere. That can be protected by a patent. But before you can have a patent, you must show that that invention is new. What you have created is new. So from the old cars where we had the gear, isn't it? The, what is it called? The stick shift, what is the manual? Yes, the manual gear. Now we have a lot of automatic gears, isn't it? Now we have the air cushion to protect from accidents. Now we have the tracking system that if the car even gets lost, it's possible to. All these are inventions that have added value to the car. We have cooling devices. We have, I gave some examples previously. We had, you know, initially we had the television that, the black and white that had doors. Then later on the regular ones, and now we have the flat screens. So inventive activity happens in diverse sectors. The important thing is that it must be new and it must add value in that sector. Once you are able to show that that is the case, then you can apply for a patent. And it's after the application has been made that one is now free to disseminate the information. Otherwise, the patent will be held to be invalid. Then we have another category of industrial property, which is an offshoot of intellectual property. And that is called industrial design. Designs deal with how things look. So whereas patents deal with how things work, designs deal with how things look. We are talking about the outward or aesthetic appearance of products. Why do you think a design might be important? I mean, it's easy to understand that, oh, a new product, maybe a new drug, responding to a health challenge, or responding to needs in the transport sector, skincare, and so on. But when we talk about design, why do you think, what role do you think a design would play in industry? Who wants to help us? Maybe those in management, business, and so on, or any sector for that matter. Why do you think, what is the importance of a design? Who wants to help us? Sorry?
When a product is well designed, the first and foremost, it will attract the audience or consumers, and then it will help in the marketability of that product.
Excellent. Thank you very much. A well-designed product helps in the marketability of the product. So sometimes it's not about utility. And the example I always give is that the cars that we have now, the new models, maybe from the 2000s, 2000, and think of them and compare them to the old 1970s model cars. What's the distinction? Those ones are made of what? Very hard metal, isn't it? If somebody hits you, that's not a problem. They will beat it back, and you won't see any mark or difference. But the ones we have now are not even so rugged, isn't it? However, almost every year or every 2 years, the different auto sectors or industries come up with new models of cars. So this is the new design. Oh, the lamp, yes, is now shaped in this particular way, and all that, appealing to the buyers, trying to draw the said, it helps in the promotion and the marketability, because before you buy something, you first must be attracted to it, isn't it? You must like the way it looks. And sometimes you are saying, oh, although this one is, is more durable in this, before then I would, I like this one. And industry operators know that. So they have design departments, they invest in this, and those who are in sectors, even within the university, who are in sectors where, they can, where their training or their discipline enables them to come up with those kind of ideas, can partner with industry. They can come up with designs which they can market to industry, provided they understand well they need to protect what? Their intellectual property. And the discussion, the negotiations, and the subsequent agreements are all carried out within the framework of well-established, contracts. And I tell people, sometimes we don't want to be too formal in our sector. Sometimes you are engaging in business with somebody, you don't want to say, oh, okay, I'll bring you have to sign this first and all that. Because we shy away from those things. And it looks like, oh, maybe the lawyers are the troublemakers who would create delay and cause obstacles when we start saying you need to do this or that. Sometimes you don't even have to be that formal. You can visit and discuss with somebody, and thereafter just send an email or a message, isn't it? Which provides permanent evidence, right, of the discussion. Thank you very much. It was great interacting with you today, isn't it? I would, further to our discussion, I will be that kind of thing. That will capture it. It's there. And once people know that you have that, then, they're a bit more careful. Perhaps more importantly, again, I keep emphasizing that, is the need for our universities to have in place, IP and innovation centers or technology transfer centers that cater to different categories of rights or innovations. So, designs deal with how things look. Patents deal with how things work. Designs deal with how things look. Then we have trademarks. Trademarks represents what we can describe as the reputation or the goodwill of a business endeavor. Because the trademark is how the product is identified. When you go into the shop and you decide what brand of toothpaste to buy, isn't it? That's the trademark you are looking at. When you decide what brand of milk to buy, when you decide whether you want a Toyota car or you want a Honda or, a Mercedes-Benz, that's the trademark. And the trademark, the value of the trademark depends on the impression of the public, isn't it, about the product. Now, where does trademark come into the discussion in the university context, you might ask? Many of our universities now, including mine, are engaged in the production of certain products, yes. Now we have water, isn't it? Bottled water, which you can afford to sell at a premium. Because most people will feel more comfortable taking water, maybe taking bread or other things that come from the university. The impression will be that at least we know this one would have been subjected to proper, standardization and all that. Now, if somebody somewhere in, I don't want to mention any name, but out there is at liberty to say the water or the bread or whatever it is that they are producing is OBAFEMIF AWOLOWO University bread, what effect is that likely to have on the trademark or the business reputation of the university, especially if the product is not standard? If it's not standard, then people get worried, isn't it? Because when they pick up the product, they can't be sure, is it genuine or is it fake? Even if it's up to standard, it will have an effect on the university's, yes, not just on the trademark, on its income, the income it generates from the product. because they are now taking undue advantage of the good name or reputation of the university, isn't it, to market their own goods. It's a different thing if the university enters into a license agreement with them, or even a franchise, where they say, okay, you can produce it, but under our supervision. So we're going to come in for quality control and all those kind of things. But again, that has to be strategic. So there are so many things that the university can leverage on, that we as individual staff can leverage on, depending on our, the sector we are in, to make additional money for ourselves, for our institution, and also to contribute to the solving of societal problems, to add value. Many times now, ASU is about to go on strike again, and people will say, ASU, what do they even want? And then they'll start to abuse us, that what are we even doing, isn't it? Because they don't know the effort, the time, the labor spent carrying out research, coming up with new things, and they may not know if everything ends in the laboratory or ends on our shelves. But the moment we realize that all these things, this knowledge we are generating, this research, is actually valuable intellectual property, which we can commercialize, which you can leverage on, to solve societal problems, including to generate employment. Right now, some universities are even trying to partner with industry, to partner with financial services sectors and other investors, to see how startup companies can begin to, emerge from the new products or the improved products resulting from the research and development activities of university teachers and researchers. If we have that, then like Stanford University and Silicon Valley, where you have a whole new industry, a whole city practically developing around a university because of the products being generated, being marketed. I mean, if we're a country of close to 200 million, we have our own markets. It just requires us to be deliberate and strategic about the research we're engaging in, to ensure that, look, it doesn't just end with, oh, I want promotion, so let me quickly publish, and once it's published, we get the promotion, we move, we become professors, and that's it. Whereas in other places, even the fact that you have come up with a patent, one patent, is equivalent to many publications. Not just in terms of the value, but also for an enhanced reputation, the product is. So I don't know which university or which, I know that it's, there's a research body, a research, what is it called, unit, which some years ago came up with this drug used for the management of those with sickle cell diseases. And we were told it was very effective. At some point, the drugs were no longer available. You can imagine those who had started using it, depending on it, at some point, for some reason, it could not be. Everything is a problem. Even things that have a market, ready market. We are not strategic about how to ensure continuity, how to develop it further, how to take it even beyond Nigeria to other places. They say it's a black man's disease or condition, how to reach out to other sectors where it might be useful, and to think of what else we might, begin to develop from there. So all these things are very important for us to reflect on as scientists, as researchers, that we are not just there, to do the research simply to teach or to engage in community service, Our research now must be impact-driven, impact-focused. It must be strategic. It must be deliberate. It must aim at the solving of societal problems. And when we have that, we need to also have in place an appropriate strategy, which also includes not just a policy framework, that's the IP policy, but also a research and innovation office staffed with multidisciplinary staff. You need the law people there, you need the scientists there, you need the business or management people there, and so on. You need the social scientists there, even the language experts. You need them there because, as I said, it's a whole package. And when it then goes out, there's every confidence that, oh, this is something, you know, that is worth it. I don't know how many more minutes, how much more time I have, so that we can have a bit of interaction, and then I go to the wrapping up phase. Okay. Okay. So the interaction is included in the 40 minutes. Okay. This one. Okay. That's fine. So go back to, yes. So, intellectual property rights. What's the nature of the, I've told you the different types of rights. Can I have some water? Thank you. We have two broad categories of intellectual property rights. Or, yeah, when we talk in terms of, you know, the benefits that we derive from our intellectual property, from the output of our intellectual efforts or labor. We have the economic rights and we have the moral rights. Two categories. Thank you. And at the end, I'm going to ask us which one we think is more important, the economic rights or the moral rights. The economic rights are the rights that have to do with pecuniary advantage or pecuniary benefits that we can derive from the commercialization, the exploitation of our rights. When you are acknowledged as the owner of an intellectual property, it's like you are the owner of your house. You decide who can sleep there. You decide what you want to use it for, whether you want to use it for yourself or you want to commercialize the house, you want to make it into a guest house, who are the kind of people you want there, and so on and so forth. The same thing. So the law says that the owner of an intellectual property right has the exclusive right to exploit or deal with the intellectual property for commercial purposes. That includes the right to sell the product, the right to manufacture the product, the right to import the product. And that also includes the right to otherwise deal in the product, to license it, and so on and so forth. For copyright, that's the literary works, the artistic, musical, and so on works. You have your book, you have your music recording, and so on. The law says you have the exclusive right, again, to deal with it for commercial purposes. And this includes also the right to disseminate it to the public, the right to translate the work. So you can have a textbook now, or you can have a novel. Maybe those in the arts who engage in writing. Can somebody go and translate the work and say, after all, it's not? Whereas even the translation also involves some intellectual effort, isn't it? A lot of intellectual effort. Those of us who interpret, maybe in our churches or in other organizations, know that it's easier to speak directly than even to attempt to interpret what others are. But when somebody goes to translate your work, that person has infringed your copyright or violated your copyright. Yes. The owner of the work has the right to adapt the work. So you can have a novel. Many times you see a novel being adapted to a screenplay, isn't it? which is then made into a film, you know, it can be serialized and so on. They cannot do that without your permission. So everything that has to do with commercial exploitation, the law, the copyright is like a basket of rights, which the owner is exclusively entitled to. So copying does not mean just literal copying, that you've copied the exact form. No. In whatever shape or form the copying is coming, whether through adaptation or otherwise, it's a violation of the right. The only limitations, okay, or exclusion is for certain limited public interest purposes. So for example, the law says when the intellectual property is used for research purposes, that's not a violation of intellectual property. Yes. If it is, you know, like now somebody has invented something, you now take it to your laboratory, you are trying to find out what is it made up of, what's the component, you know, okay, how can this be improved? This drug helps to manage this condition. If we add this to it, will this still work? As long as for research, you cannot commercialize it until the patent has expired, which is after 20 years. But for copyright, it is between 50, yes, you will in a bit, ma. For copyright, the right expires between 50 and 70 years after the death of the author. So, so if you write a book now, that's why the law says it's a form of property that you can pass on to your children and your children's children, whoever you want, you know, because if it's a joint work which involves two or more collaborators, two or more authors, the right will expire. Let's say it's a book. That one is 70 years. For artistic works, it's 50 years. So if it's a book, the right will expire 70 years after the death of the last author to die. So if there are three, the last one to die, and then 70 years from then. So if that book is made into a novel, is made into screenplay, is used for, without the permission of not either the right holder or his heirs and assigns, that's a violation. So you find some musical works that are still, you know, subsisting today, even though the owner of the copyright has since died. But after the term, and that's the same for trademarks too. So the name, the Peak milk, Peak, the Omo or Ariel detergent, the Toyota for the car, and so on. That one is even of indefinite duration because, you know, the longer, the more valuable, isn't it? Like Coca-Cola now. Everybody knows Coca-Cola has been there almost forever. It will remain, you know. So depending on the category of the work, patent is the shortest, 20 years from the date of application for protection of the patent. Thank you. Yes, ma'am.
Okay, I said that if you go to the lab and improve on an innovation, and it still has a patent, but you take it to the lab and you improve on it. I'm a pharmacist, so you do some additions and you bring out something better. Do I have to wait till the patent expires before I can bring out such? Can I patent first? So it still has a patent and it's still running. It's not 20 years, but I've come with an improvement. What happens? Do I have to wait till that one patent expires before I can do my own patenting?
Okay, thank you very much. That's the business decision you have to take. Legally, you can file for a new patent because the law says you can patent a new invention and you can patent an improvement on an existing invention, as long as that improvement also satisfies the requirements of newness. You've added new value to it. But yes, but the business decision, I said it's a business decision because it's now for you to decide whether if you put that new thing in the market now, what effect will it have on the product that is yet to expire? And you have to weigh that decision against the possibility of somebody else coming up with the kind of invention you came up with and rushing to patent it, because you won't be able to say it's my patent, it's first to file. If you do it and keep it, in your laboratory or in your mind, you don't bring it, and somebody else does it and goes to file it, the person is the owner of the patent in the eyes of the law. So it will have to be your decision to decide whether you want, to leverage on the previous invention for a while and ensure that you obtain all the benefits you can before you bring this one out. Yeah. Okay. If it's not the same person, it's still the same thing. Another person can go and patent an improvement. Okay? But if your ability to produce that product depends on using their own. Maybe an example can be, let's use engineering. Maybe, let's say somebody invents a part of a motor vehicle now. And that thing cannot be marketed or used without the motor vehicle. You can't say, oh, because I've invented a new kind of gear or a new steering, you now make the whole car. So you may want to approach one of the car manufacturers and say, look, I want us to have, I want to license this to you, or I want you to license, give me a license to produce your car because I want to use this. That would then be a business negotiation or discussion. Yeah. Question? Yes. Okay.
All right. My question is about instruments, standard instruments. When I was doing my PhD, I requested for permission to use an instrument, and it was just giving me over 12 hours. I sent the man, found his email, sent him, he replied, and I got it. I used it. Then, subsequently, there was another instrument I wanted to use. In fact, I used my previous experience. I thought that all I need to do is to send this man an email, send this other person an email. They will normally reply and approve. I went ahead and used the questionnaire and sent, I was looking for his email. The first one I sent came back until I kept looking until I now found the email. By the time I found the email, I've already designed my questionnaires. The truth is I was already administering questionnaires. But the response I got was, I was sent to a website. So if you want to use this man's website, this instrument, go to this site. I went to the site. It said the site is being administered by my son. I have retired. And then you must pay. You must pay how many dollars? I asked for permission. I'm from a developing country. Say, no. You have to pay the full amount. So I was stuck. I was stuck at that point. Now, can I just improve a little on that instrument and escape that law? Or should I just abandon that work?
Yes.
Yeah, just like him, I sought permission also from someone that designed a questionnaire, and in the agreement form she sent, because she responded almost immediately to and sent an agreement form, and in that agreement form, I remember clearly they said you are not to translate this questionnaire. You are not. They listed out so many other things we were not meant to do. But in getting to field, I realized that the people I was going to administer this questionnaire to did not understand English. I'm dealing with special needs children, and many of them don't even understand when you converse with them in Yoruba, talk less of English. So I sought advice from a senior colleague because I knew that going into translation was another work on its own. There are many steps in translating a questionnaire, and I did not want to do that. So a senior colleague advised that I could verbally transcript this questionnaire. That's if, let's say, I want to tell a child, do you like to brush your teeth? Do you brush your teeth yourself in the morning? I said, sure, man. So instead of administer, it can be researcher administered, where I administer these things to them, but say it in Yoruba. But there are so many biases involved in that because depending on my own mood and the way I don't speak Yoruba very well, yes. So it's been very difficult. Can there be legal implications for even doing that verbally?
Okay, thank you. Now, earlier on, I said that intellectual property belongs to the right holder, isn't it? If the person who owns the intellectual property had used his or her time and effort and resources in creating something else or purchasing something else, you won't say because you have an emergency, you jump inside my car outside and begin to drive it away. That, oh, you are doing it for the benefit of a certain, you understand? Aha. So, I mean, that's one way to look at it. And what the two questions have also thrown up is the issue of the internet now, digitalization, information sometimes that we download, that we access on the internet, and whether, I mean, when somebody just puts information on the internet, some people put images, pictures, and all that. Can you just download it and use it? No. It's safer to assume that the information is protected. Because as a researcher with a reputation to protect, it can get very nasty when, you know, it now comes out that, oh, you are even, you know, taking undue advantage of other people's intellectual property rights. So you find that information, the fact that it's out there, that it's readily available or accessible, does not mean that it's in the public domain for you to use without permission or without authority. It's always better to ask for permission and no assumptions. For some, I mean, there are different categories of you know, copy. They now call it even copy left online, you know. Instead of copyright, it's now copy, some say copy left, which means, you know, free use of information, open access, and so on. But what is called open access? When you go to the website, you find that there are different kinds of licenses. There are some that allow you to use it freely, so long as you are also not making any money, any commercial returns from it. Some allow you to use it and repackage it even commercially. Some say you can use it, but you have to acknowledge the source or attribute, you know. So there are different, you have to understand what the owner requires. And if you need permission, it's always safer to ask for the permission first. If you use it without permission, it's one of two things. The owner of the intellectual property, who is called in law the licensor, that's the person who is entitled to give you a license right, can decide that, okay, if you had asked for permission, this is the license fee I would have charged. So you've done it now, pay the license fee, and that's the end of it. But there are others who, for some reason, would want to insist on, you know, yes, going the whole, yes, deploying every available legal solution, which also includes putting out the information and so on. So now you are into this, you've been told you have to pay a license fee. Sometimes it's easier to negotiate when you haven't used it yet. But once you have started, it becomes a bit more difficult, but you just have to negotiate. That's it. That's it. Now, for her own question is slightly different. You know, I said earlier on that even when you translate, when you adapt, as long as it's still that same work, you know, it's the copyright owner who has the exclusive right to do all of those things. And by extension, the right to permit others to use it. But, you know, I said earlier on that there are limited public interest exceptions where you want to say, oh, I'm using this thing for research purposes. You know, there's even the educational use limitation or exception. But it's limited. If I say, oh, it's for education, I carry your textbook and photocopy it for my students. So who is going to buy the book? When I say, oh, educational purpose, I mean, if I copy the abstract page or copy the introduction, do you understand what we're saying? So sometimes it's a question of degree. You have to look at the use. What's the market? What's the traditional market? What's the effect of this activity on that traditional market, you know? So, because the creator of the work, unfortunately, and sorry to say, is not government. It's government that usually does the kind of work that will say, okay, use it for this category. They are the ones collecting our taxes. They are the ones collecting the rest. So they are the ones who can, you know, do those kind of public interest things. So if A uses his own money to buy a car, B uses his own to buy a house, I use my own to pay researchers to do research work, to come up with something, and you say, oh, because you want to, you now use it, you are violating my intellectual property rights, and the law will stop it. Any other questions before we continue? Yes, one. Any other one? 2, 3, 4. Okay, let's take those 4.
Thank you very much. My question is on property rights, copyright. I'm in political science, and the word conjecture has been there. Has been there before I came into academics, but I try to bring it into political science and specifically contextualize it in gender. I try to push it into publications. I've published something on gender conjectures. In fact, recently I was asked to define it in my own understanding, the way I know it, and it was published. My question is, can I still claim, or is it possible for me to claim copyright on that definition of the word gender conjecture?
You know, what we're trying to do this morning is something that we are covering a vast field. So maybe the advantage of this approach is that it can elicit specific responses. We have to look at, when we say copyright protects intellectual works in certain sectors, there is also a question of degree, the degree of work, the substantiality of the work, as it were. So, for example, is a title protectable? Do you understand? If you say, oh, this is the title of my book, and somebody else has gone to write a book with that title, or somebody has gone to create music with a similar title as my music or film, is it protectable as copyright? The answer is no. Yes, because the law tries to strike a balance between the protection of individual rights, private rights, and public interest. We all take from the available information. In fact, one justice of the Supreme Court of the US said, is there really anything, you know, there's no knowledge that is totally new. We all build on existing knowledge. We add our own value to existing knowledge. So if you look at the film industry, for example, those of us that like me, You know, that's what I do when I have some few minutes to relax. I like to watch films. Now, if we look at our own Nollywood, and we think of what do the artists, the dramatic art people call it now? Is it the plot or the theme or the storyline? I mean, we can count on our hands the number of storylines. Is it not going to be either the wicked stepmother or mother-in-law, or the husband that is philand, or, you know, I mean, we can readily tell. In fact, for some people, once they start watching, after the first five, they say, this is what is going to happen and all that. So can we say that, somebody has written on the wicked mother-in-law, nobody else can write on it again, or anything like that? You understand? So in the same way, you know, the law says nobody has the exclusive right to an idea. Ideas are not protectable. Ideas are in the public domain. But when you take that idea that is in the public domain and you labor on it to build it up into something, you create an intellectual property in that. But again, it has to be substantial enough. So you are talking of maybe a title or a definition, if I got your question right, you know, now, if you know that that definition, maybe this so person defined it in a particular way, acknowledge the source. That's good intellectual, you know, or ethical behavior in academics. But it's not to say that people can claim explicit. The work has to be substantial enough, and that's always a question of fact. But there have been cases where the courts have said it's a title. This person wrote on this title and now, or it's a similar theme or a similar plot. That's why sometimes it's difficult to prove. You know, one of the areas where that sometimes prove problematic again is with regard to what we call confidential information, you know, like maybe somebody comes up with the idea of, what do they call this TV, all these TV reality shows and all that. They go to the TV station to say, I want to introduce a new. So it's going to be a question of fact whether what that person is bringing is just an open idea that is in the public domain, or he has worked on it sufficiently to make it unique and different from what is already there. So that's why sometimes, as I said earlier, it's good to kind of reduce what you have, you know, into writing so that it will be clear if it needs to be determined whether or not it is protectable. Has the response helped? Sometimes I have to know some more facts, but I can talk about general principles. Okay. Okay. Number 2. Yes.
Thank you very much, Ma, for that enlightening speech. I quickly want to ask, for somebody who is from the Department of Mathematics, for instance, you develop models. And I understand that these journal houses, they already have certain copyrights. Some of them do copyright under the name of the journal house. Some of them do it under the name of the authors. If I develop a model, send it for publication like that, do I need to copyright my model before sending it out, or the copyright done by the journal house is sufficient for me?
Thank you. You know, earlier on I said, unlike industrial property, copyright does not need to be registered. But the Copyright Commission has what is called a notification scheme. If you submit things to them, it's like they just warehouse it there. You know, you keep it there. In case something comes up in the future, it's a referral, you know, it's a reference point. You can say, on this date, this was what I created. A lot of people are concerned about copyright in our publications. When I first joined and I started writing, as I said, sometime in the 90s, even as a copyright, an IP a scholar. I wasn't thinking about who owned the copyright in what I was just interested in getting my work published. But it got to a point that I published in one journal, and most journals will at least give you a complimentary copy. Then this one said I had to come and buy the journal myself. What is, And then at some point, the university said, oh, you have to submit your journal to the library. They want to put it on this thing and all that. And some would complain about. So that was when we started asking questions that, what's this about? These days, you find that most journals, especially when you publish internationally in the foreign journals, they'll give you a contract to sign with many pages. And sometimes it's a kind of standard form contract. Take it or leave it. So I know that sometimes maybe if it's a collaboration involving faculties or whatever, sometimes they'll send it to the faculty of law and say we should look at it. And we also try to raise questions and all that. And you know what those people would say? They'll just say, oh, it's standard. That's what they use. They understand the point we are making, but it's either you want it or you don't. It's like they know how the market works. They know the advice. It's like a business negotiation where your negotiating position determines, whether you're able to do give and take or you maintain your ground and you are sure that people would come. So what am I saying? Ordinarily, the law says the first owner of copyright in a work is the author. So when you author a work, it is presumed. You don't even have to talk about it. It is presumed that you are the owner of copyright in the work, in your own particular work. The publishers own the copyright in the journal, in the entire journal. But in your own particular work, you are the first owner of copyright. When you submit your article to them, it is assumed that you have given them a license, which is just permission to use to publish your work. Do you understand? Which means they can publish it. That assumes that as the first owner of copyright and in the absence of a contrary agreement, you can also publish the work or use it for other purposes. But if there is a contrary agreement, which is the contract they often give us to sign, some will say you cannot do anything with that work for a certain number of years. Some will say not at all. Some will say not without permission. Now we have digitalization, online publishing, and so on. Initially, we were not thinking about it. You sign a contract that has to do with physical publishing. They say now they are going online, pay-per-view, all those things. Do you understand? And it's not even covered by the contract. And initially, the law was on the side of the author to say, oh, you can only take the right of the author to the extent specified by law. That is in the contract. But now, online publishing has become so well established that it's now largely considered to be, once you sign away your right to publish or to use, you understand, it's deemed to be part of it. Do you get what we're saying? So if you've signed a contract, the right you have is a function of that contract. If you have not signed any contract, you remain the first owner of copyright, but you cannot sue them for the publication of the journal, whether physically or even sometimes online or in however way, because you are deemed to have given them a license to use it. But you cannot say because your journal is somewhere in a book, you now publish, not just your own, but the others there. And because it's your own intellectual work, you can still use it. That's the general rule. But if you have entered into a contract and you have signed away the rights for a limited period or for an indefinite period, that's it. Now, there's no copywriting as such. Copyright comes into existence the moment the work is created. That's why the law says you don't even have to, you can choose to register it with Copyright Commission, you can choose not to. Once you have expressed the idea, put it in writing or in other permanent form. The law says once it's put in a permanent form from which, it can be perceived orally or, in writing, permanent form, you've recorded it, you've written it or whatever, copyright immediately subsists in that work. So you are putting it somewhere, registering or notifying it's just for purposes of evidence should the need arise. Okay? Yeah. So, but what you can always claim, and that's why we're talking about the difference between economic rights and moral rights. Economic rights are rights that have to do with pecuniary benefits. What you do when you sell, when you translate, when you give permission to adapt, and publicly disseminate and otherwise. But moral rights are personal rights. And those rights they are personal, they are perpetual, they are inalienable. That means they cannot be sold, they cannot be transferred. And what are the moral rights? The moral right, the first one is what is called the right of paternity or the right of attribution. The right of paternity, you know what paternity means, that I'm the owner, it's my child, isn't it? That is the right to be acknowledged as the author of the work. So no matter whether they publish it online or through physical or whatever, they cannot substitute somebody, they can't take away your name from there. Wherever it goes, it has to be linked to you. And that's why Shakespeare may have died several hundreds of years ago. There's no more copyright. So I can even go and start publishing and print Shakespeare or whatever. But I can't say Prof Oyewumi, Macbeth. It's still Shakespeare because that right to be acknowledged as the author is a permanent and inalienable right. It can't be transferred, it can't be sold. All right. Number 3.
Thank you, Ma. My question a bit somewhat answered, but I still need more further clarifications. Is that can copyright be shared in this sense? I write a book in German. Someone is reading it possibly in the East and found it useful and wished that the book be translated to Igbo. But based on what we have said earlier, that even translating work is also an intellectual exercise. Now, if the person decides to write to me that he wants to translate my work, but I want the copyright to that title, to that book, can that copyright now be shared with him, having translated the work to another language?
Yeah, thank you. The person who translates a work with your permission as the owner of the copyright in the original work has copyright in his own translation. Okay? But he has to acknowledge, even in that translated work, that so work, translated by, do you understand? Your name has to be there. He has to acknowledge you as the owner of the original work. This translation is known as a derivative work. It's an adaptation of the original work. And the law gives you the right in perpetuity to be acknowledged. So if you write Macbeth or whatever in Yoruba or in Igbo or in Hausa now, it still has to be acknowledged that that is Macbeth, the original, as translated by. That's why even when you are watching a film, if it's a film is adapted from a book, they will tell you the original title and the author, isn't it? And then the screenplay was made by so, and so on. And then this is the director, this is the... So when a work is being modified or being adapted with the consent of the owner remains the copyright owner of the original work. But, of course, he's asking if he will give money. When we are talking about a license, what do we mean? That's the modes of commercialization of a work. So you decide that, for copyright, you want to give maybe one of the filmmakers permission to make it into screenplay. That permission, that license, is a commercial agreement. It's a commercial agreement, and I think I have some of the clauses you even look at somewhere in the slides, which will be given to you. So there are a lot of things that will be included in you have what is called a license agreement. Then you have what is called a franchise agreement. Then you have what is called an assignment. There are different ways of commercializing your intellectual property to make money from it. So you can decide that license simply means permission to use. If they're not going to give you money, why are they asking for your permission? Actually, it's just to put your name there, isn't it? They will put the name and use it. But the law says you have economic rights. As long as the person is still, as long as the copyright has not expired, which is 70 years after the end of the year in which the author, died. Then, when he was talking about sharing of copyright, I thought he wanted to talk about also co-ownership. It's possible. Joint authorship of a work, for example, or a patent that is jointly made. So these days we find that there is a lot of collaboration going on, isn't it? And then it's a matter of agreement to decide, in what proportion ownership and benefits will be shared. But we have to understand that ownership of intellectual property is not for those who just carried out ministerial or administrative tasks. Maybe they help to type the work, or you must also contribute. There must be adequate intellectual input into the work. So if there is an invention now, we've discovered that, if we take a certain substance and mix it with another one and administer it in particular doses, it's useful for curing certain ailments. And 4 of us carried out the research, maybe 2 from medicine, 1 from pharmacy. We also had somebody from what did you call it? Biomedical science or something. And as long as all of us have contributed, intellectual, it doesn't have to be in equal proportions. Because even when you're talking about proportions, we talk about quantitative value, we talk of qualitative value. For some, the one thing they bring in can be the defining factor, But what is important is that they must have added value in the context of, what makes up that invention. So co-ownership is possible there. And where you own property, you decide what you want to do with it. You can have a house in the village and say, they can use it for guest houses when people come home for functions. You can say, lock it up. Even if it's once in 5 years that I go there, that's when you understand. That's the same thing as intellectual property. So for commercialization, you can decide that, I just want this thing as it is. We've created one model, that's it. You can say, I want it to really go round. I want it to be. So you decide to give licenses to different bodies or organizations to produce. But they've said that researchers are not usually good business people as well. Maybe because, there's too much. Is it when you are walking around in the laboratory, when it comes to negotiating business, running around, looking at agreements? And it's not about money. Those who have managers, some people have managers now, and that's what institutions are trying to do, to create that office where they also have the business managers that will do that for you. Because otherwise, many people, the things you even give away for free in terms of information, business people are scandalized when they say, you can't do that. That's, that can define or redefine. So many of these, when we have issues, they've not given us this and all that, there are even things we can leverage on that you don't even care about, whether government is, but we are just walking around. We are so overwhelmed. You are supervising projects. You have a PhD. How are you going to be able to think of business? So many people don't think about it. But if there is a business office and innovation office managing that, reaching out to industry, helping, all that remains is to have a good IP policy in place. Our own IP policy in the university says 50% of whatever comes in belongs to the researcher. And then the remaining 50%, part of it to the university, part to the faculty, part to the department. You know, everybody benefits. But that will be of the profit from it. So if it is not commercialized, how are you going to profit from it? And then you look at different models. If you decide you want to give a license, what are you licensing? If it's a copyright now, maybe those that are in the arts, in literature, who write and all that, this thing is turning to look very appealing. You can decide that, oh, you'll give certain people the right to translate into different languages. Those are separate licenses. Then the ones that have the right to adapt it into a screenplay, that's a separate license. These are different commercial agreements, you know, for which you get remuneration. And the remuneration, it depends on the negotiating capacity and all that. It can be a lump sum payment. It can be royalty that is payable per use. It can be periodic, you know. And the internet and digital technology has also brought in a new dimension. Many of us are still carrying our physical books around. You send your books to somewhere for them to help you sell it. You will see neither the book nor the money. Because it's very easy. Somebody has sold the book for 5 or 10,000 in 5 places. Okay, let me quickly use it for this. Before you know it, the money has built up. The person won't pick your call again. But now, it's possible to, yes, sell pay-per-view. This one is technology. There's no shortcut to it. So you just be seeing the alerts. It may look like small money, but it's adding up into your accounts now instead of into somebody else's account. There are different models. So this one is even like automatic copyright, that once you don't refuse anybody. Once the terms are met, you know it's claimed. But the traditional models are still there. That still serves its own purpose. But there is now the new online model. I mean, I just discovered all of a sudden that formerly, you know, when someone is traveling, people will say, oh, help me to bring this, or help me to give somebody that. You carry cassette, video cassette, all those things. At a point, we just saw that those who are there have watched many things, even before you arrive from where the thing is made here. Then we saw that, okay, they're watching it online. Actually, I did my PhD in that area because that was the time digitalization was coming up and the impact on intellectual property, especially copyright. And I saw the different models. And I did my work here and also with co-supervision from the Max Planck Institute at Germany. At a point, I was sent back home again to come and interview some of the Nigerian entertainment operators in the entertainment industry and so on, to find out these filmmakers whose films, you know, I had sat down to know some whose works could be accessed online for payment. Then I was sent back to come and interview them here. That's when you even interact with them. How much are they really earning in terms of foreign exchange? And I was surprised, shocked to discover that many of them they were not earning a kobo. So who was collecting? So people were putting their works on there and saying pay-per-view without recourse to them.
My husband's work is being sold in the library of a university abroad. She can confirm it. 2 of his books that he wrote from his PhD work. What's the name of the university? Is it Stanford or something? Library. The books are there. We saw it early this year. When I was going through, I love exploring. Because of the digitization you talked about, moving our books online, I enrolled for e-creation, e-book creation. I'm mastered. I have a master's degree in e-book creation, how to migrate your book to online, especially on Amazon platform. I have 2 of my books there now. So I was going to help my husband move his own that he published years back. And we now saw the 2 in a university library locked with a fixed price. With his name, Olumakaye Humphrey Bamishebi. The title of the 2 books are there. Fixed. And we are here in Nigeria. Didn't earn a dime. They are thieves, intellectual thieves. How can you help me? I will see you as a lawyer.
Because, that's not an educational use exception at all. Because they are making profits, without authority. Ordinarily, books are archived and kept in the library, isn't it? You can use it, you can read it for limited and all that. But when this online environment is a different ball game now, and we really have to study it and understand it. That's, when I got there and they said, oh, your country, your Nollywood it was the third at the time, later on it became the second. You have a vibrant, and they wanted me to focus. You know how they like to know about her. So I had to focus on that particular angle, and I spent months, collecting information and all that. And then they sent me back, paid my airfare, and said I should come back home and spend some months at home again and find a way to. So I had to go to the collective, copyright association. They linked me up with some. And to be honest, even the collecting nobody was any dime in foreign exchange. So while we are still running to Alaba and going to catch the boys selling books on the road and going to the port to say, oh, they are bringing in some books from China. Online, behind you, money is dollars, pounds, and people did not know about it. There's even more awareness now. So who are those operating those websites, those new business models? Even there was a time a musician, I can't remember his name now, sued one of the telecom companies then. Because this, is it ringtone or what is it called on the phone? Yes. They said, oh, if you want a particular music as a ringtone, pay something, a certain amount. So the person too was like, just to test it, paid, tried to reach, and they said he should pay. He paid for his own music. I won't divulge the name of but it's even a case. They actually instituted action. And then when there was good and all that, but eventually, unfortunately for lawyers, lawyers will like the case too, so that the jurisprudence can develop and we can use it to teach and do research. Apart from the, no, not for money. But unfortunately for the lawyers, they settled. They said, okay, that is how bad. So you have your music and they're saying it can be used for this thing. You can imagine the number of subscribers to popular networks now paying, I don't even know how much it was. Those were the early years. Yes. Now it's 15 naira. At that time, it was a bit more expensive, So there are so many things going on. That's another example of a book, online. And the owner is here, maybe calling the person he sent 50 copies to say, you only returned money for 20 copies. And some people are, and all that. So new models are evolving. That's where commercialization comes in. That's where being strategic. That's where even having an umbrella body that can assist with following up of all these things. It's so important. Yes. Oh, okay. Sorry. Let's
Now, the questions you have is still based on the topic, right? Yes, thank you, Prof. The discussion is quite interesting. Initially, I was feeling dozy, but when I started hearing about right, and this thing, I quickly come back to my senses. It appears there are rights for everything, and there are laws for everything. And there is something interesting that I've also captured from the discussion we've had so far. I was about to ask this question, man, that every information we have, be it online or in hard copy, how do we know those that are copyright protected and the degree of protection? I also find it interesting to ask this question, man. How do we distinguish ideas in the public domain from those in the private or protected domain? I'm asking all this question because I don't think there's anything new. Even the concept of research has to do with, there is something existing you're trying to modify, you're trying to improve on them. So the idea of saying some people have an exclusive right to some information protected, I still found that a bit confusing. So how do we distinguish a document or an idea or an image that has a substantial right? Do I also have a substantial right to use any information I found in the public domain? And lastly, must we always seek for permission? I went online, I saw some interesting pictures. I want to use them. I don't know the source. I don't know the owner. Do I have to start looking for the owner before using them? Or perhaps, what if we have a source that indicates, oh, this is the owner? And I kept assessing, like my friend here who said he tried to assess some people and they didn't respond on time. And I have a deadline to catch, but this thing is very interesting. And all efforts to assess the rightful owner, so to say, prove about it. What do I do? Most of the information is there. Is it in the public domain? I don't know. Is it in the private? I don't know. So how do I know this? Thank you.
Okay, so you see information somewhere. It's better, safer to assume that it's protected. You see here, we don't really appreciate or value those things. But those that operate in systems where if you are caught, the kind of, even the damages is financial or, it's compensation, financial compensation, which you'll be asked to pay to the owner for violating his intellectual property. Those that operate in those domains. I remember back in the day when this digitalization first came up, some of those who were deemed to be violating intellectual property were even university students. They were the ones downloading music, people's music, using different the peer-to-peer technologies, all this MP, whatever, that they used to download to share and all that. And at a point, they had to administer a subpoena. Subpoena is like a legal mandatory requirement, mandating the university to disclose the information of the owners of particular, each person has his own IP. So the recording company went to the courts and obtained an order mandating because the university too was trying to protect, to say that, oh, they could not violate the privacy. There's no privacy when you are breaching the law, violating other people's. They obtained this, and the kind of damages they slammed on those students, I don't know where they expected. I think they just wanted it to be punitive and exemplary, so that others would, refrain from it and know that, look. So you can't say because you've been seeing that car out there for 1 week, nobody has come to move it. You now enter it and say you want to be driving it somewhere. You don't even know how the car got there. So you say, oh, it's there. If the car was not there, will you not find a solution to your problem? So that's how, we look at these things that, okay, I wrote to him, I put a notice on the car and nobody responded. So I asked my, what is it called, panel beater to come and find a way to open it. When you get to the police station at Sabo, you'll be arrested there. And that's still stealing. So it's better, it's safer, but in our own environment, because awareness is still being raised to some of these things. Now, the law is very simple and very straightforward. If you look at the Copyright Act, is there anybody from Faculty of Law? Ah, okay. Welcome. Yes. So, yes, if you look at the Copyright Act, in section 1, that's the first section of the act, and you can talk to the lawyers after I've left, or you also have my information. The law just simply says that copyright, the eligibility for copyright protection is hinged on 2 basic principles, just 2 simple ones. That the work must be original in nature and it must be in fixed form. It must have been fixed in a medium from which it can be perceived, you know. Now, originality is a topical question. What do we mean when we say a work is original? Does it mean it must not have been known before? No. Originality simply means you have not copied it from somebody else. That you have used your own words to express your thoughts on it. So, that's why you can have 100 textbooks on physics without one violating the other. In law, we have different textbooks, maybe on the law of conduct. You may use the same cases because you are not going to go and fabricate a case or a principle in mathematics. It's still the existing one. But how you describe it, how you explain it, that is, even a case has held that there is copyright even in examination questions in mathematics. And somebody was saying, how different can the questions be in mathematics? It's fairly straightforward that this. I said, no, if it's that straightforward, go and create your own in your own words. There are some that will be so similar because of the very narrow scope that it's hard to tell the difference. And that's why these days, you know, I'm going to be telling you all the tricks here. Sometimes, you know, when people want to, something like a calendar, you can't change the date, isn't it? It's the same thing. So you want to create a diary, you just, the list of justices of the Supreme Court, this and that, you just copy what somebody else has done because it's the same information. And that information that is common like that, if historical value or newsworthy or whatever, is the same information. But some people would put something just slightly different somewhere in the middle of it. And that's what they will use to prove that they were, it was copied or infringed. Because if you are giving information about different, okay, this is in the public domain, the justices of the Supreme Court are all this. What about this one? Maybe it's supposed to be a Mr. Justice and you put Mrs. Or it's supposed to be Milord, you put Mile. Just something different, or just alter the spelling, just something like that. And then that's how the person will be caught. Because it will look like it's information in the public domain, but you can prove that, look, this one is not original, you copied it. You copy, it's a verbatim copy, and this is what is there. Now, sorry, in relation to her own question, it's a very straightforward matter, really. Because there is evidence that he is the author of the work, and there is no evidence whatsoever that any license or permission has been given, you understand? And there is no evidence of any returns being made and all that. In fact, the risk is that sometimes the longer you wait, there is what is called laches and acquiescence in law. When you are aware of your right and you sleep on it for too long, and it's shown that, you've known that I've been using this thing, you know, that's no excuse. But it can happen to the extent that it will now be assumed that, okay, you don't mind when you are aware of it and you don't take any steps, not even to write a letter to say cease and desist and render account for all sales made so far. Now, sometimes you say something, sometimes you write, you say something, they quickly take it down and you don't have evidence. The law, that's why sometimes people get away and they'll say, oh, the law is an ass. The law is an ass because the law can only act where there is evidence. And in the online environment, sometimes you see something today, tomorrow is no longer there. You are looking for it, but it was here. So what are you going to do? You know, I told you about the music and the company, the telecom company. The person first bought. He himself applied to buy. Paid, had the evidence that he himself bought. So that when the whole thing came up and it was like, this is the evidence, you will catch them. You don't catch people like this that they can sleep on. You hold them very well. So you have to be strategic. Consult the lawyers. We'll tell you the rest. I won't deny my colleagues of their brief by... but...
No, I said I asked a question about adapting a standard questionnaire.
I've already talked about adapting a work. You cannot adapt it or modify it without permission. You can't. Yeah. Yes.
Good afternoon once again, everyone. We was trying to ask that, how do you know the works that are in public domain and the ones that are in private domain? When we're using our search engines, especially Google, I know that when you get to advanced setting, you will pick, are you looking for common license material that are for open use? When you search on the domain, anything that comes out under them, they never expected you to ask for any license or whatsoever. You are free to use them. You will just reference, this is so image. If everything is to be asking for permission to use, then the academic world will be stagnant. Thank you, ma'am.
Thank you very much. So on this note, we would like to bring the discussion to a close. Oh, you want to say something?
Yes. Yes, there are some websites that are open access. But, even on those websites, if you check, you'll find that the kind of license, open access is of different types or categories. Sometimes you will find the information there of what you can use. Now, if you go to Google Scholar, for example, you know, there are some Google Scholar, Social Science Research Network, and so on. There are some that you can access freely. There are others that are still locked up, that are maybe pay-per-view. But it's always safer if there is a license in there, use it. Even if there is no license, acknowledge the source. It's important. Open license does not, or open access does not mean that you can, the moral rights are always there. The ones that are open and access, but when it comes to things like maybe drawings, images, and so on, you have to be careful and make sure that it is free information. Otherwise, you may find yourself on the wrong side of the law, and you don't want to be there, especially as academics. Thank you.
Thank you, Prof. I'll ask Professor Olumakaye to come and give our vote of thanks. But before she does, let me just appreciate our participants. You've been wonderful. Although the number has reduced substantially, I don't know why. But for those of you that have been faithful in those last 4 trainings, we just want to say thank you. Especially the changing of venue. It was beyond our control. I want to say that we have 2 more trainings, but we are not doing them now. So please don't ask for certificate yet. You will get the certificate, but it is after we have concluded the 2 sets we have ahead. When we are ready, we will inform you. Please don't exit the WhatsApp platform. And let me also thank you for keeping it, is it sanctified? It has not been bastardized. So don't bastardize it. No New Month greeting, no Easter greeting, no greeting. Just let's leave it as it is. Thank you.
On behalf of the management of AWOLOWO University and the Fellow of University Administration Support Program and the participants, we want to sincerely appreciate our resource person. We've really learned a lot from you, and the lecture was an eye-opening session, especially from me. I think I'm already feeling some dollars, thousands of dollars richer. Yeah, my sister, I remember you. We want to thank God for you. Thank you very much, and we wish you journey mercies back home. One of the take home here is the narrative has to change. It's no more publish or perish. It's either you publish or perish. We are not perishing. We are not going to perish. We will publish, we will patent, and we will prosper. So that's our slogan as from today. We will publish, we will patent, and we will prosper. None of us will perish. We will all get to the zenith of our destiny and career in life in Jesus' name. Thank you, thank you, thank you very much. We've really enjoyed ourselves. I would engage you further after now. Thank you very much. And wish you all the best as you enjoy as you strike holiday.